Hi, my name is Catherine Harris, and this is my presentation on the Cheyenne and Arapaho Tribal Court for tribal courts and Indian country. History of the Cheyenne, Tsistas, and Arapaho Ananahe tribes. The Cheyenne, Tsistas, are descendant from the Allegheny tribe. They lived along the Mississippi River in the Great Lakes region in what is now Minnesota. They initially farmed corn, beans, and squash, and later set off to be hunters and gatherers. The Arapaho, or Ananahe, people lived in the Great Lakes area beside the Mississippi River until they were forced off their land to move west to the Great Plains. The Arapaho had to adapt to their new land and make weapons and hunted buffalo. In 1796, the Arapaho moved and set up camps along the Cheyenne River near the Black Hills in South Dakota and became allies with the Cheyenne tribe. The tribes hunted together and moved their camps together and made their way to northwestern Oklahoma. This alliance helped strengthen their presence on the plains and expand their territories. Tribal courts pre-IRA had a more traditional and culturally based system of dealing with legal issues within the tribe. Post-IRA, the Western way of running the government was incorporated into the traditional way to make a governing structure in which both ideas were represented and created a difference in the way the tribes had to adapt to conflicting views and laws. The main difference between the two systems was that the Western-based system was expressed through writing and individualism and the majority rule philosophy, where the traditional system was more oral, spiritual, consensus-driven, and trial-based. The Cheyenne and Arapaho Treaty was negotiated 11 months after the Sand Creek Massacre that occurred on November 29, 1864. The Sand Creek Massacre is a hugely significant event to the Cheyenne and Arapaho peoples, as it was when the United States Army volunteers attacked the tribe's encampment after they had flown a peace flag. Over 150 Cheyenne and Arapaho people were murdered, including children. As a result of the devastation, the United States sent over commissioners to negotiate a treaty with the tribes. The treaty essentially promised payments for 40 years to the tribes as reparations, and also offered a reservation on the Kansas and modern-day Oklahoma border for loss of property and land grants, and loss of lives of loved ones. But this treaty was filled with empty promises. The reparations never came, and Kansas did not allow for the reservation. In addition to this travesty, Chief Black Kettle was killed by Custer's 7th Cavalry attack on a tribal camp near the Washita River. History of the Cheyenne and Arapaho Tribal Court. The Tribal Justice Center for the Cheyenne and Arapaho tribes is located at 100 West Black Kettle Boulevard in Concha, Oklahoma. Their tribal jurisdiction spans Beckham, Blaine, Canadian, Custer, Dewey, Ellis, Kingfisher, Roger Mills, and Washita counties. The judicial branch is compiled of a system of courts and judges that interpret the laws that are made by the legislative branch and implemented by the executive branch. The tribal court handles cases in civil, criminal, divorce, juvenile, delinquency, and guardianship. There is an appellate review procedure laid out in the Cheyenne and Arapaho Tribal Law and Order Code. One must file a notice of appeal with the clerk of the tribal district court within the time allowed. The DOJ, or Department of Justice, is tasked with completing the executive branch's obligation under Article 7, Section 4A of the tribe's constitution to implement the laws of the Cheyenne and Arapaho tribes. The DOJ works closely with the BIA, which is the Bureau of Indian Affairs, and select departments within the executive branch of the tribe to investigate nefarious behavior. Cheyenne and Arapaho tribes have tribal codes, acts, and ordinances, and through the tribal court, legal aid programs provide basic legal advice and representation to tribal members. The Office of Tribal Attorney is the chief legal representative to the Executive Office, directors, tribal programs, and staff. They cannot provide legal assistance to individual tribal members. Cheyenne and Arapaho court officials, judges, and types of cases. Currently, the governor is Reggie Wasana, and the lieutenant governor is Herschel Gorham. The judge and justice is selected based on a nomination by the governor and must be confirmed by legislature and must be approved by the tribal council. The court consists of the following positions and departments: court administrator, court clerk, legal aid services, Modoc Nation Tribal Child Support Services, Office of Tribal Attorney, Probation Officer, and the Bureau of Indian Affairs Law Enforcement. There are also numerous boards, commissions, and task force, as well as CAP, which is the Cheyenne and Arapaho Productions. This is the first Native American owned and operated broadcast TV station in Oklahoma. The tribe also has the Tribal Tribune, which is a bi-monthly news publication for citizens of the tribe. In terms of tribal membership, according to the Cheyenne and Arapaho Constitution, tribal membership is determined by names on the membership roll and blood degree. Currently, there are 3 associate judges: Juan Garcia, Michael Belonger, and Richard Phillips. The court dockets are every week by case type. The Cheyenne and Arapaho Tribal Law and Order Code covers everything from jurisdiction, sovereign immunity, declaratory judgment, and pleadings, motions, and orders. They also offer a wonderful legal aid program. The legal aid program can assist in all types of cases. Some of the cases that are handled by the program are as follows: defense of misdemeanor criminal charges, defense of felony criminal charges if the statutory range of punishment includes a term of imprisonment of 10 years or less, defending parents or children in deprived juvenile cases when appointed by the court. When completing the legal aid application, the following documentation is required. First, a copy of Certification of Indian Blood, or CDIB, a copy of the driver's license or state-issued ID, and the name of the county in which your case is located. The attorneys can support the tribal members with obtaining a tribal court order if the defendant or defendant's assets are off reservation. They can provide representation assistance to those who may be facing the loss of their housing through eviction. They also offer services to represent tribal members where the state or county is legally attempting to exercise jurisdiction over them or their Indian land. Cheyenne and Arapaho Tribal Constitution. The tribes work under a constitution that was adopted in 2006 and uses 4 branches of government to maintain a divide of powers: the executive branch, the legislative branch, tribal council, and the judicial branch. The judicial branch contains a Supreme Court and 1 trial court. The judicial branch can distribute funds annexed by law for the judicial branch. Here is a copy attached of the Constitution of the Cheyenne and Arapaho tribes. The Cheyenne and Arapaho Constitution contains a Bill of Rights in the first article, followed by Article 2, which discusses the government organization of the tribe. Article 3 covers the territory and jurisdiction sections. Article 4 discusses membership. Article 5 focuses on the tribal council, followed by Article 6, which discusses the legislative branch. Article 7 is the executive branch, followed by Article 8, which is the judicial branch. Article 9 discusses everything to do with elections, and Article 10 covers sovereign immunity. Article 11 is the referendum. Article 12 discusses removal, recall, and vacancies, and Article 13 covers amendments. Cheyenne and Arapaho customs, traditions, and culture preserved in the courts. The tribe has an elder services program that is very important to the tribe, as well as the healthcare program, family and community programs, and language, culture, and educational programs. The tribal council meetings are often started with an elder doing an invocation in their native language, followed by a membership roll call. The elders offer a Cheyenne and Arapaho cultural program that helps to preserve the tribe's customs, arts, social institutions, and progress within the nation. The cultural program also contains representatives of the Native American Grave Protection and Repatriation Act, or NAGPRA. The Sand Creek Massacre representatives are also a part of the cultural program and work with the National Park Services to maintain the Sand Creek Massacre site and tell the true stories of the events there. It also covers the CAP program, which is the Cheyenne and Arapaho TV broadcast station, as well as TARO, which is the Tribal Employment Rights Ordinance, to assist in preference to jobs for qualified Indians. Wellness courts and the tribal court system. The Cheyenne and Arapaho tribes have a healing to wellness program that provides treatment, provides community resources, supports through cultural and spiritual aspects, and provides judicial supervision to maintain treatment and recovery. The Healing to Wellness program provides support to tribal members to live clean and offers specific services to promote and protect the recovery of offenders. This program was created in 2014 due to a grant in response to the increasing issue of alcohol and drug arrest within tribal jurisdiction. This program empowers tribal members to actively participate in the programs to sustain the recovery and their treatment. The importance of tribal sovereignty and tribal courts. Tribes have spent many years trying to protect their sovereignty from interference of outside jurisdictions. For tribes to flourish, there needs to be self-determination and tribal autonomy. The discussion on tribal sovereignty was rooted in the 1800s with the introduction of the Marshall Trilogy of cases that discuss the political status of tribes in the United States. With the courts settling on the status being domestic dependent nations, the courts went on to decide that tribes contained the inherent right to sovereignty and had the right to make their own laws. Tribes have since walked a tightrope between managing their own internal affairs and tribal courts with a dissection of the outside jurisdictions. Tribal courts are so important to the safety of tribal communities as well as the prospering of their economies and legal infrastructure. The scrutiny and criticism of non-Indians to tribal courts brought on the Major Crimes Act in 1885. The U.S. had already started the approval of courts of Indian offenses, or CFR courts. These courts were originally created to deal with crimes in Indian country. The strength of the tribal courts is essential to the survival of the tribe's sovereignty and culture. Thank you for watching my presentation on the Cheyenne and Arapaho Tribal Court.